Good afternoon. My name is Dr. Gabor Lukács. I'm the president of Air Passenger Rights, and this is your bi-weekly Sunday afternoon Air Passenger Rights update. I would like to start with thanking our volunteers, Dominic, Terry, Martin, and Christine, who have helped me to get through this past 2 weeks with moderating the group, with providing feedback and keeping an eye on things in general. I would like to remind everyone who enjoys this group that without this amazing moderating team, I would not be able to run this group. So we owe them a lot and we owe them a lot of recognition. I'm being told now that audio video is perfect, so we can start momentarily. I'm also going to have a look at what's happening with comments, and we are going to talk today mostly about chargebacks and clawbacks and the difference between them, and try to distinguish between the various procedures that are available to draw more clarity how things work. Most of the time, you will be probably looking at, not at me, but at some kind of blackboard that I improvised. Hopefully things will be legible. If not, you are welcome to tell me and we are going to make some adjustments. So here's a blackboard, and we are going to talk mostly about the various mechanisms in place, and I'm hoping to cooperate here, various mechanisms in place to deal with situations where you are not getting what you are supposed to from your bank, from your airline, and how we can find that. So there are several ways, and let me do. So there are several ways several things we are going to talk about. We're going to talk about chargeback, which splits to internal and statutory. And then we are going to talk about clawback, which is a kind of last-ditch solution when the chargeback procedure doesn't work. Now, I'm sure when you look at this, my writing, you realize, poor students who have to read Gabby's writing. Yes, I do have horrible writing in general, and writing on a kind of tablet type of surface doesn't make things any easier. So when we are talking about chargebacks, most credit cards have procedures where you call the credit card and tell them, hey, I didn't receive the services that I was supposed to receive. And then a credit card is reversing it, writing to the merchant that the card holder is saying they didn't receive the services that they paid for, and therefore please address it, please respond to it. That is the internal chargeback procedure. The next possibility is the statutory chargeback procedure. We already spoke about it. Most provinces, in Ontario, for example, it is the Consumer Protection Act, have some statutes that under certain circumstances require a credit card issuer to reverse charges. So in Ontario, for example, it would be sections 99 of the Consumer Protection Act that require that. Section 99 ties back with other sections of the Ontario Consumer Protection Act, namely Section 7 sub 1, which we discussed last time, which prevents any kind of contract from contracting out, from waiving the rights under the Act. Section 26, which allows a consumer to cancel a future performance contract if they didn't receive performance. And Section 96, which requires the merchant, the vendor, to issue a refund promptly if there is a cancellation for under Section 26. And promptly, it means 15 days. The regulations in the Ontario Consumer Protection Act say 15 days. And then, so in terms of the statutory chargeback process, it would work as follows. I'm going to use different color for that if I can find one which I haven't used before. Let's try now, blue. So you first start at section 26. You notify the merchant, the vendor, that because they haven't performed the services, you are canceling the contract with them. Then you come to section 96. They have to issue a refund within 15 days. And when that doesn't happen, then we come to number 3, which is a statutory chargeback on your credit card, and you have to do it within 60 days. So 60 days after the time to issue a refund has expired, that you have to within 60 days, pardon me. Oh. Within 60 days of that, you have to request that kind of refund. Let me just move it. Right? And let's move this as well. Too much. Here, we're talking about Ontario. So this is a statutory chargeback. Internal chargeback is something we spoke about, and that's what you really have mostly experience with, which is when you call a credit card company and tell them I want a chargeback. And for example, MasterCard will typically allow you 120 days for filing such an internal chargeback. Visa also speaks about that. And in many cases, the two procedures are intertwined in the sense that your internal procedure is very similar to the statutory one, and it can be argued perhaps that if they do the internal procedure correctly, it may meet also the statutory obligation. The reason that they have an internal chargeback procedure is precisely because there is a statutory obligation to also issue chargebacks. That is what happens if things go properly. Under, say, in Ontario, under Section 99, the credit card company, the credit card issuer, issues you a credit to your card, and that becomes permanent. They don't reverse it. End of story. But what happens if you do have a hostile credit card issuer? What if the credit card issuer simply tells you, you know what, I am not going to give you this, or I'm not going to do what is the right thing to do, which would be to issue you your money, your credit, give you back your money. So in that situation, the last resort is clawback. Now, before I'm going to insert another step between these. I'm going to move this a little bit further. So in between here, I'm inserting another step, which is, I don't know what I wanted, which is removing the money. Remove temporary credit. So in the internal chargeback procedure, they typically give you, in many cases, a temporary credit until their investigation, their back and forth with the merchant is over. And what my suggestion is to remove that amount of temporary credit that you get into a real bank account. And the reason is that if they then go against you and want to rebill, so they may try to do a rebill, after the merchant files some kind of dubious documentation, dubious statements, then you don't have your money held by the credit card company. When they rebill, it is no more than them saying, well, we think you owe us this money. And you can then respond, well, think again. The timeline for how long they can remove the temporary credit is not quite clear, and it may vary from credit card to credit card. But what you need to bear in mind is that when they rebill you, it is no more than the credit card saying, we think you owe us. It is not actual money they are removing from you. the reason that I'm saying to remove temporary credit into your bank account, because money in your checking savings account is actual money. That's your money, and for anybody to take it away from you, they need a court order unless you voluntarily give it up. Anything in your credit card is a claim against you. It's when they say you go and buy groceries for $100, that $100 will show up in your credit card, and it will be a claim that the credit card company is saying, we claim that you made this transaction and that you owe us this money. But it is not actually money taken away from your bank account yet. It becomes the money taken away from your bank account when you actually pay it out and reimburse the credit card company for money that they have given already to the merchant. This brings us to the notion of the clawback. So clawback is a kind of last resort, and it ties back with the removing the temporary credit, because in some cases you don't get a temporary credit. So if they go against you, the next step is to claw back the money from your credit card. In other words, spend down an amount equal to the amount that they owe you under a chargeback, and tell them, sorry, that's not your money, it's my money. Your statement is incorrect. You have to reverse those charges, and since you refuse to do so, that's too bad. You will have to sort it out with a merchant. I'm not paying it. So I would like to perhaps go through with you on some examples to try to make sense of what's happening here. So let's suppose, I'm going to see if I can do some typing here. So let's suppose that the ticket cost was $1,300. And let's suppose that your current credit card balance is, say, $800. That's how much you spend this month. And suppose that you have already paid down your original ticket. So then, if you get a temporary credit, so this is we start from this situation. Let's make here a here. Oh, what? Let's make here a nice box around it. So this is where we start from. Okay. Now, once you do a chargeback, so a situation after chargeback would be a new balance which is, I would write this minus 500, which means this is a credit balance with a credit card. I'm marking it as minus 500 because normally credit card balances are the amounts that you owe the credit card. So now, and maybe I should even make it clearer with the other previous window, that make it a bit bigger here. Okay. Let's make this a bit bigger, leave here more room, and then we can. So this $800 here is a balance that you owe the credit card company. So now you have a new balance, a credit balance, which is $500 that the credit card company owes you. So now let's just go back what we had here. You're going to remove you're going to remove the credit balance. So what you do is you take that amount that is now in credit in your credit card and you move it to your bank account. And then balance, we have a new credit card balance after removal, which will be $0. That's the ideal situation where you don't owe anyone, they don't owe you anything. It's just a perfect situation. Nobody owes anyone anything. So we are going to make here a nice, very nice green frame around this. And so that's a new balance. Now, suppose that for some reason the credit card company now rebills you. Then we are going to have a new credit card balance, which is $1,300. The original value of the ticket, CC claims, you owe them. Okay, so now what you do is simple thing. You refuse to pay. Because you did not get the services that are at issue. You were doing a chargeback because these were not genuine services that you have received. Rather, these are amounts that you were charged for something you have never seen, never received the services. So the effect here, just to be clear, is that this $800 that you were owing, that was paid off by the temporary chargeback. There was a $500 surplus, which is your money. You took it out to your bank account, you removed it to safety, and then you have a new $0 credit balance, which is normally, that's the point where things should stop. Normally, that's where the story should stop. But if they rebill you and they claim, no, actually, you owe us $300, you tell the credit card, I think otherwise. I disagree. And not only refuse to pay, but I would say, of course, rebut. And ultimately, tell the credit card company to go to court. You tell them to go to court because once you tell them that you dispute an amount and you tell them to go to court, then they cannot take collection actions against you in Ontario. If they try to do something to your credit card, to your credit rating, your credit score, you can fight it back because it is a disputed debt. These credit ratings and credit reports are for situations where the debt is undisputed. If you dispute the debt and you have good grounds in this case to dispute it, you didn't receive the services, then you need to have a paper trail. And this is why I am always telling you that you must have a very good paper trail. Just not paying credit card bill is a bad idea. I would never suggest you to simply not pay. That's inappropriate and can get you lots of trouble. But having a paper trail explaining what you are not paying, why you're not paying, and being extremely careful about not paying only those amounts that are owed to you, that's really your money, and they're trying to get money that is illegitimate, that's a different story. Daniel is asking whether it applies to Quebec as well. The answer is yes. Quebec's Consumer Protection Act, and I'm going to mention that as well. So since the question came up about Quebec, let's talk here about Quebec a little bit. So in Quebec, the provisions that you want to look at is starting at 54.1 of the Quebec Consumer Protection Act and all the way to 54.16. The most important stuff happened around 54.14, 15, and 16. Those are provisions that deal with the chargebacks. There's a question here from Tony. How can the credit card companies get away with not doing their job? It seems that most of the credit card companies are just partnering with the airline without a fight. Can I sue them for not acting as a mediator? In other words, not doing their jobs. So Tony, let me tell you this. First of all, the airline's job is not to act as a mediator. Their job is to make sure that your charges are reversed when your credit card transaction is inappropriate. So once you notify them, their job is not to mediate. That's just what actually American Express, for example, wants to describe your situation as if their job was only to go between you and a merchant. Absolutely not. They have to investigate and they have to be impartial and they have to ensure that they are complying with the law. If you comply, especially in Quebec, if you comply with the formal requirements of giving a notice of cancellation for services not received, and then comply with the timelines, you're talking about a statutory chargeback. And your clock starts only after you give the formal notice of cancellation, which gives us a lot of leeway, even if the informal or internal chargeback didn't go your way. Then the clock starts only from the point when you give the formal notice. And if you comply, especially in Quebec, with the formal requirements, they don't even have a choice whether to give you a chargeback or not. They absolutely have to reverse the charges. They have no discretion under Quebec statute. Now, Bob Jason is asking, what if I never paid them initially? My PC MasterCard reversed the charges. Should I cancel my card? So if you, let's maybe go to a second page. I'm first time using this tool for a multi-page situation. So please bear with me here. Tools, pen, new page after. Okay, should have now a new page after. There we go. So looking at the same situation that Bob Jason is asking, in that case, Bob, you have a situation where you originally have, a balance of $1,300 because you didn't pay at that time your bill. Sorry. That's your original balance. And then once you do a chargeback, get a temporary credit, you end up with a zero balance. Which is zero, which is good. We are happy about it. That's the best situation. I'm not suggesting to take out more money than what is yours from a credit card. That would be wrong. In this situation, if they try to rebill you, then you are back to a situation where they claim you owe them some money, and you tell them, sorry, I don't. So I've seen some questions about British Columbia, and let's go back also to British Columbia. In British Columbia, the chargeback laws that are quite clearly applying, one should perhaps research it a bit more thoroughly. But the things that I'm sure that apply is for distance contracts, so situation where you made a transaction on the phone, on the internet, and then in BC they have the British Columbia Business Practices and Consumer Protection Act, and the articles, the sections you would like to look at is 49, 50, and 52. I'm going by memory, but you can verify it. Those are the BC provisions. Now, if you go to announcements, then under announcements, one of the items you will see is a link to a big article which lists the consumer protection legislation for most Canadian provinces where we have one. Leslie's asking about New Brunswick. I'm not an expert in New Brunswick law, but to the extent I was able to look up, New Brunswick is probably one of the few provinces that doesn't have a proper chargeback provision. I would double check. I wasn't able to find it, but it doesn't mean it doesn't exist. It may be hidden in some regulation. So for example, in Alberta, if you look at the Consumer Protection Act, it may not be clear that there's such a provision, but if you look at the regulations, Alberta has good regulations on online transactions, internet sales. Same thing with Nova Scotia. Nova Scotia Consumer Protection Act, Section 21AF. Mention it. So Nova Scotia, it would start from Section 21AF of the Act, but then you have to also go to the regulations. There are a lot of regulations that deal with the issue of chargebacks for online transactions, and it is important that you read those as well. But as I mentioned, again, we have a whole post about that. Back to the issue of how we are going to deal with situations. So we first dealt with a situation where there was some kind of balance owing. We got a temporary credit, and then we removed it from off the bank account. Then it was rebilled, and we refused to pay. Second situation is when it hasn't been paid off. We get a temporary credit, bring us to a zero balance, or possibly even a balance owing, and then we get a zero balance or balance owing. That's fine. There is no action needed. If they attempt to rebill you at this situation, and we are going to talk about it in a moment, then you pay off things all but the price of the ticket. So let's look at this scenario here. And suppose that you have a credit card balance of $1,700 with a ticket costing only $1,300. That makes an interesting situation. So once you get a temporary credit, you will be still owing to the credit card company $400. That's a bit different scenario. Now, in this case, what you do is you pay the $400 which you owe the for other purchases which are unrelated to the one that you dispute. Of course, you always pay your bills. You don't leave an unpaid bill other than the one that you dispute. And if they try to rebill you, so let's continue with the idea that after this happened, say they attempt to rebill you. And then we are back in the situation where this credit card balance is again $1,700. So what do we do then? What we do in that case is pay $400 because that is the amount which is not being disputed. We always pay any amount which is not in dispute and refuse to pay the amount in dispute. So once you pay the $400, you are going to end up with a new balance of $1,300. Let's move it. So after that, we end up with a balance of $300, and this is the amount that you refuse to pay. So maybe we should actually move it a little bit up. Let's move this is up here, and this is when you refuse to pay the amount in dispute. This is the logical order of things. So you obviously pay what you don't dispute, but refuse to pay the amount in dispute. Let's talk now also about the notion of clawback. And this is, we have already spoken about it, but there's essentially, suppose that you have already paid off your ticket. And again, our assumption is that the ticket is $1,300. So suppose that you have a ticket which costs $300, and we're going to talk about clawback. Let's talk about clawback. So suppose we have a situation where a ticket is $1,300 and the balance is zero. That's because, say you've already paid off the amount. And suppose that the credit card company refuses to issue you a chargeback. They are being uncooperative. Then the point is to spend down the credit card to the extent of your ticket. So incur expenses up to $1,300. Now in reality, it will not be exactly $1,300, but let's say that you spend maybe $1,350. So then your credit card balance your credit card balance is going to be, if you manage to do it perfectly, it's going to be $1,300. But let's say that you are not doing it perfectly and you end up with $1,357 owing. That's more a realistic scenario. And then we do what we discussed before, which is this model. You don't dispute the $57 that is owed to the credit card company. So you pay $57, which is undisputed. And then we are back in this scenario where we have a $1,300 balance, which is the amount of the dispute, and you refuse to pay that and tell your credit card company that you refuse to pay. You explain why you refuse to pay, namely because it's not a valid charge, and you tell them that if they don't like it, then they can take you to court. Of course, one has to pick the words very carefully. Now, I'm asked here by Pat Agger, if the client is a resident of Ontario, third-party agent is based in Quebec, the airline operated the flight, departure and return point both in Quebec. flight operated by a Moroccan airline. Flight return to Morocco to Montreal cancelled by the airline. Do Ontario consumer protection laws apply, or is it Quebec? It's a very good question, Pat. I would say that if the client is a resident of Ontario, there would be a strong ground for Ontario laws to apply because there's a real and substantial connection to Ontario. That's typically the test that courts would be looking at. However, even if the Quebec law applies, chances are that the passenger is equally covered. So if there is a doubt, perhaps the letter should mention both laws, that based on the Ontario section blah and based on Quebec consumer protection section blah, I'm canceling the contract and you're required based on section so and so and so and so. You mentioned both provinces' laws to provide a refund within 15 days. And once that's over, you write to the bank and we make sure that your letter of chargeback meets both provinces' obligations in terms of the formal chargeback. My instinct is, and this is not something I have research, so it's just a flag worth researching, is that likely the province where the consumer resides, that is likely the province that will be taken by the credit card company as a first instinct approach to what is the governing law. I would say Anya is asking, which credit card department do you explain your intentions not to pay? I would first of all record all calls. That's a very important question, and we need to be clear that we record always all calls with credit card companies. I would advise the disputes department, but then I would put it into writing. I would put it into writing because it's an easiest way to ensure that you have a paper trail. I would possibly fax it and email it. And if you want to be super sure, even registered mail to the credit card company, sending out briefly that you dispute owing this amount, you don't recognize it as a valid debt, and you therefore will not be paying it. In a couple of days ago, I've seen a really neat form in British Columbia to address that, a specific form that is being recommended and used for notifying the creditors that you dispute a debt. Ontario may have something similar worth checking, but it can be also freehand. I'm disputing I'm disputing this debt, and therefore I will not be paying it. It's not legitimate, and if you disagree with me, please take it to court. The BC form can be good guidance for you to see what kind of information you should be putting in. And in terms of clawbacks, this is pretty much the procedure. I would suggest that clawback should be a last-ditch resort. It is not a routine thing to do clawbacks. Clawback is really a situation that you do if there is no other way for you to get back your money because they are being so stubborn, so hostile, that there is nothing else that you can do. It is important that you will be able to show that you have gone out of your way to show your credit card company that this is a legitimate charge, to provide them documents, rebuttal. So it's not like, oh, well, I made one phone call, they told me no, so I'm clawing it back. Make sure to have a proper paper trail. Make sure that you really exhaust all possibilities before you opt to it. One more thing to remember about the clawback is that you should also refuse to pay any interest that they attempt to charge you for a debt that you don't owe. You don't owe the principal, therefore you don't owe the debt. They can charge you on paper some interest because it's their records. I can start a nice ledger telling everyone that they owe me $1 for each minute of my time. So what? It doesn't impose a legal obligation on anyone to pay me. Just because I have the conviction, the idea that someone owes me money, that is not turning into a legally enforceable right of payment that is owed to me or payment that I can collect on. So you need to remember that there is a fundamental difference between your credit card and your bank account. Your bank account stores actual money that you can anytime withdraw, and it's your property until the time that a judge ordered otherwise. Credit card is more like a loan situation where transactions are recorded and the credit card company says that you owe us this money. It is simply their opinion on how much you owe. Ultimately, of course, a judge will decide whether you owe that money or not. And I would by no stretch of imagination suggest advancing any kind of questionable arguments under the chargeback process. That's not what it is for. It's not for situations where you just don't feel like paying. It is obvious for situations where it is a legitimate charge. In terms of the chargeback process itself, you can tell your credit card company, I disagree with you. In some cases, you may even want to cancel your card just to create clarity. I'm not doing business with you anymore. I don't believe I owe you anything. You think otherwise. It bothers me, and therefore I'm stopping to do business with you because I'm not going to do business with a credit card company that doesn't respect my rights to a chargeback. And if you still think I owe you something, you are welcome to sue me in court. Let's talk a little bit also about the risks and what can happen. Many times we discuss this, and I'm coming back to it once again. You're going to hear things like, oh, we're going to send it for a collection. The first thing to deal with such threats is inform them that they cannot send it to collection under your province's laws. In most provinces in Canada, and if it comes to it, where I'm happy to research it for all provinces for you, a disputed debt cannot be acted upon by a collection agency. If you inform the collection agency that you disputed debt and you inform them that they are welcome to take it to court, that's where collection stops. Many people don't know that. But if a collection agency continues to do anything, harass you or so on, that's a matter for the police. There's a Joe here outside my building who is making here a scene. I've already advised the collection agency that I don't owe this money. They don't have a court judgment. So have them picked up by the police and remove them from your property or from your house or from your apartment. They don't have a right to harass you. Again, if you abuse it, a judge will frown upon it, of course. But we are talking about the true to God situations where you didn't receive the services, you attempted to do a chargeback, the credit card company was ignoring your right, and now they're trying to use illegitimate means to go after you. That's what this situation is for. Now there's a question here by Nusha. Should we then cancel the card with the balance of the trip on it? The answer is, if you have exhausted all normal avenues, I would cancel the card with the balance on it. You can always cancel your card, and you can inform them, I consider this matter closed. Just look up on the internet on all this corporate lingo, the most annoying corporate language that you can find polite about, we understand you feel otherwise. However, I'm regretting to inform you that, ... We understand that you would prefer a different resolution. You're welcome to file a legal action against me in the small claims court of province, Ontario, provided maybe even with the address of the nearby courthouse to your home. Being super formal, super proper, because you don't have a reason to be concerned. You know that you are right. And put things into writing. They can tell you something on the phone, I would record it. But if you put it into writing and you're sure that you have proof that you sent it, that's where things end. If they send you more letters, you send right back to them, sorry, I consider this matter closed, and further discussions will not change my position. I'm comfortable with my position. That's what Air Canada loves to tell people. We are comfortable with our position. Well, you can tell them, I'm comfortable with my position, and if you disagree, you're welcome to take me to court. If they call you after this, say, perhaps we should one day make a separate session on what happens if some collection agency calls you. But the kind of thing that I would do is, hi, I'm from the collection agency, blah, blah. Good afternoon, sir. Can I have your name? I didn't hear it well. His name, okay. And can I have your contact information? Phone number, email address, the address for your company, just so that you have it right. Make them spell it correctly. Just make sure that you have first all this information. Then, sir, may I ask you, do you realize you're calling me in, say, province of Nova Scotia? Yes. are you licensed as a collection agency or collecting agent in Nova Scotia? That will be the first time when they will give them a pause. Because in most Canadian provinces, you cannot just become a collecting agent or agency because you want to do it. You have to first get a license. If they're not licensed in your province, that's where the conversation ends. Sir, it was very nice talking to you. However, because you're not licensed in the province of Nova Scotia, I'm Nova Scotia, I'm licensed in Ontario, unfortunately, I'm unable to entertain this call further. Please have one of your colleagues who are licensed in my province to call me back. Have a good day. And you hang up. Option B, they are licensed in your province. Very good, sir. Now, although I don't have to tell you, sir, but I'm informing you as a generous action to make sure that you're aware that this call is being recorded by myself. Oh, you can't record my call. Well, sir, that's actually not the case. Under section 183.1 of the Criminal Code, I can record a collection agency. And I can record my own conversation. If you don't want to continue this conversation, you're welcome to terminate it. I'm advising you that by continuing this conversation, you are agreeing to be recorded. Just turn the table on them. Same thing if they tell you, hi, I'm calling you on the recorded line of such and such company. That's great. I'm recording it too. So we both have a recording. I hope you don't mind, sir. And then once you have gotten all their information, email, fax number, name of the agency, then you say, well, sir, I dispute this debt, and I will be sending you shortly a letter in accordance with the laws of my province, informing you that I dispute the debt and informing you that you are invited to take it to court. So I ask you that you call me back once you have received it, just to confirm you have it, and you understand that based on the laws of the province, after that you cannot contact me until you have a judgment. Have a nice day, sir. So, I always think when you deal with people who behave this way and who try to exercise power over you, I always come back to think about my late grandfather. Historian, intellectual, not a particularly physical person, and at some point, police officers showed up at his door. It was in 1990, in the summer, right around the change of the regime in Hungary. Still, in those days, people were concerned and afraid of police officers. It was not anything like democracy, not this democracy now in Hungary, but in those days it was still, people were really concerned. They knocked on his door, or rang the bell. My grandfather opened a small window, those old doors that in Europe they have, which have a small window where you can talk through it. Opened a small window on the door and says, "Good evening, gentlemen. How can I help you?" "Well, we have some questions for you." "Gentlemen, do you have a search warrant?" "No." "Thank you very much. Have a good evening, sirs." And he closed the window and went in. And that's where it ended. So when you deal with people who act with authority, being professional is very important as knowing your rights. And if they trespass on your rights, show them the door in a figurative sense. Don't even let them into your house to begin with. But you don't have to work with someone just because they have a big voice and they sound threatening. The more threatening someone sounds, the less serious they should be taken in many of those situations. They are simply trying to intimidate you, that's all. I'm seeing here an interesting comment by Alan that I would like to answer. That question is, disputed charge by Royal Air Maroc received credit to credit card account on May 25th. On June 26th, received call from RBC that RAM, I don't see the rest here. Okay, RAM disputed chargeback. Told them by phone and email I don't accept the chargeback. RBC haven't recharged my card. How long have RM to go to do something? Well, it's not clear, Alan, how long they have to deal with it. I would simply refuse to pay if it's rebuilt and dispute any kind of reversal, rebut it. If the merchant disputes the chargeback, insist that the institution, the credit card issuer, sends you all their documents. And then you can go point by point. Okay, this is a fraudulent document. This document does not say what they claim it says. This is not a legally binding document like with the Canadian transportation agencies. They depend on vouchers that airlines love to use. So you can really deconstruct their arguments in a brief letter. Brief, I mean 3, 4, 5, 6 pages, and send it back. Make sure that you have a paper trail. So Al, my only other suggestion to you is that if you do get something reversed, make sure that you build a paper trail, you build some kind of documentation around the fact that you're telling them that you don't agree with it and you refuse to pay. I mean, if there's still an open channel of negotiation with a credit card company, if they still ask you for input, I would be super cooperative, because there's no point to be hostile when the other side is trying to help you. But if they say, we close it, we concluded that you don't get this, Visa loves to do it to some people, ask them first a record for the decision, who made it, when, based on what evidence. And then you can say, well, that's nice, but I disagree with you. And you're welcome to take it to a judge. Remember that just because they act with authority, it doesn't mean that they have authority. And when you look at what the airlines are doing to you, refusing to give you refunds, which is one of the most fundamental rights in a consumer transaction, get back the money if you don't get the services, it shows how much the legal system is not able at this point yet to create law and order in a situation. So yes, possibly they can take it to court, and in 5 years there may be a judgment. But in that much time, many other things will happen. The airline may go bankrupt, which will again vindicate your choice not to pay. The airlines may, well, I believe likely will be forced to pay back the amounts. So all those things that delay the issue from your perspective, that's good, because it means that you use the money, you spend the money, and in the meantime, it is the banks, the credit card companies that end up holding the bag. The more money belonging to you get back, and even a clawback from credit card companies and airlines, and the banks and the credit card issuers, the more pressure the airlines are going to face, because the credit card companies, which are basically banks that issue credit cards, are going to be out of the money, at least temporarily. You are refusing to pay the bank, and if there's 1 or 2 people, they don't care. But if there are thousands of people who say, well, those are not legitimate charges, I'm not paying it, then the banks are going to miss some money. And then most natural address for that at that point is come back to the airline and say, hey, you should be paying this. Now, I would like to mention that as some closing thoughts, that we do have a rebuttal assistance queue. It is overwhelmed to some degree, and I'm trying to just put out fires with the most urgent things. One of the reasons is that I'm working on a number of other things these days, various other projects relating to passenger rights that also require my attention, unfortunately. Some of those probably will be reporting in the coming months about some results. And you may not know, may not have heard yet, but I'm also working on some cases that are at the crossroad of passenger rights and human rights, about those passengers who have been refused transportation to Canada, and perhaps even their ETA, electronic travel authorization, was yanked simply because they have the wrong color. They are too brown to travel to Canada. That's an issue that is very close to my heart because it's racial profiling, and I'm sure you know, mentioned many times, that I have a Jewish grandmother, Holocaust survivor, so that's certainly something that is very close to my heart. Any form of discrimination, any form of human rights is something I very deeply care about. So I'm working on some of those cases as well. But we're going to try to work on the most urgent cases. Miriam Dolan is asking, is there an actual time frame where the CC has to move the credit temporary or finalized to your bank account? Miriam, that's a good question. I don't think there is such a time frame is. If they're giving you a hard time, I would just use some cash advances as a method. If you have a positive balance, if they owe you money, you do a cash advance only to that extent and not beyond that, they cannot charge you interest for that because you are simply taking back the money which is yours. So make sure check your credit card balance. If you can spend down the temporary credit or final credit, that's great. If you cannot, use cash advances as a last resort. If they try to charge you interest, refuse to pay. Remember, with credit card companies, just because they put something on your balance, on your account, doesn't mean you have to pay it if it is not legitimate. If it is legitimate, of course, obviously you have to pay. We are not airlines. I mean thieves. But anything which is not legitimate, just because they put it on your credit card, That doesn't mean anything. It means that you have to consider it. That means you have to verify it. If you come to the conclusion that it was illegitimate, tell them, I don't agree with this, I won't pay it, have a nice day. Pat is asking if an airline canceled the return portion of a flight and did not offer any type of assistance, they might try to use a force majeure reason to deny compensation. However, the country airport had many flights departing from the days our flights was canceled. Pat, maybe we should, this is a good point to close our today's session. The difference between a refund and a compensation. A refund is simply giving you back the money you paid, but for which you receive nothing in return in terms of services. A compensation might be owed in a situation where they didn't provide the services and you incurred damages other than not receiving the services. For example, you were going to attend a beautiful concert of the Messiah by Handel or Bach, St. John Passion. Sorry, I'm biased when it comes to classical music. And because of you weren't able to fly, you also missed that performance and you had tickets for a couple $100, then those tickets have to also be reimbursed unless the airline can show that they have taken all reasonable measures to prevent the delay or prevent the situation. So if, say, I was to fly from Halifax to New York to listen to an amazing concert, and then the flight is canceled due to COVID-19, then because if it's genuinely COVID-19 cancellation, the airline has to give me back the money, the airfare, but they don't have to pay me for the tickets that I wasn't able to use for the concert, because that's no longer a question of a refund, that's a question of compensation on top of a refund. Judy is asking, Gabor, are you getting a sense that certain airlines are fighting chargebacks more than others? Judy, it's hard to know. I would say that Air Transat and Sunwing have been trying to fight very hard. Air Canada, perhaps a little bit less, depending on the situation. What I do know, and that's maybe another topic that I'm hoping to work on in the coming week, finally, it has been sitting on my table for a long time, is that we should gather some data on how much money has been recovered through chargebacks. My rough estimate, based on a very nice work of one of the members of the group, is that we are over $1 million that passengers have recovered through chargebacks, and that's without any other means of getting a refund, like just getting the airline to refund you. So that's encouraging. If you look at the topic 1 CC dispute in the group, you will see that a number of people have recently been winning their disputes, finally, with permanence. So it's an ongoing fight. Don't expect things to resolve tomorrow. Don't expect the airlines, out of the goodness of their hearts, to hand over their money, or actually your money, to you. They won't do so voluntarily, but we're going to force them if they don't do it. We see some good results in the UK. Just there was a recent article I posted probably today that the UK Civil Aviation Authority is now telling airlines that they are going to be facing naming and shaming if they are delaying refunds. And the next step may be some legal action they may be facing by the Civil Aviation Authority in the UK. So that's the good news. They are leading the charge there. In the European Union, things are slowly moving, but moving ahead. In France, there is an injunction lawsuit seeking injunction against a number of airlines that refuse to issue refunds. It's a slow process. What I'm sure is that after this, if the airlines want to get back to business seriously, there will have to be more system of security, of checks and balances to ensure that your money is really yours until you fly. That's quite obvious to me. And I hope that something will come into place in the longer run. The short run, we keep fighting. The fight is not over until we have won. This is not something on which we can compromise. Refunds is your money. We can compromise perhaps on compensation or on many things, but when it comes to your money, that's not subject to compromise. And we are not going to stop until you have received all your money one way or another. There was a quick question here, how things are going with the gathering of videos. I would love to see more of you post videos about how much money which airline stole from you. We are collecting those, and we are very fortunate to have one member who is helping with compiling things from those videos, but we would need more videos from this group of people, especially new members, telling the world how much money each airline stole from them. Those videos are very powerful because they show that this is not simply Gabor Lukács standing on a virtual barrel in the middle of a virtual park and preaching to the world that the refund is owed. It's important to convey that this is a widespread problem that affects many people. Susan is asking, do we have to follow up with the credit card company to see if our credit return is final or just not draw attention to it? Susan, I would probably not draw attention to it. After maybe 120 days, I would phone in, but generally you have the money, so it is final as far as you are concerned. If they try to claw it back, try to rebill you, don't pay and then deal with it. So just go ahead and spend it, and if they don't like it, they can take you to court. We are now at the 1 hour mark, and I think that we are getting pretty much to the end of the topics I wanted to cover. So I'm going to just wait maybe half a minute to see if my wonderful team of volunteers has any more questions that they think I should be passing on to you, and I should be answering, more importantly. And so Christine, Dominic, Marty, and Terry, any more questions that we need to answer? Anything that we still need to deal with? I'm just waiting for some feedback. Are we good to finish? I'm not hearing anything from the team, but I haven't heard a resounding, I think now I'm hearing. I think we are good. All right, folks, thank you very much for joining us today. And thank you again for the entire team of moderators who are working a lot to deal with some comments I've seen have been kind of heated lately. So take good care of yourself. Don't fly if you don't absolutely have to. Keep physical distancing, social distancing as much as needed. We don't want another second wave. Take good care of your loved ones. And we'll probably be having another live session in about 2 weeks, if not sooner, if you don't have bigger news. So take good care of yourself and have a wonderful week or 2 weeks. Bye now.